Hey guys, welcome to another video. My name is Captain Sanjit, and in this video we'll be talking about Articles 22 to 28 from the Chicago Convention 1944. I know we are still stuck with the articles, but a lot of questions in the DGC exams come from these articles, so it is quite important to cover this. So these articles, Article 22 to 28, basically talk about measures to facilitate air navigation. So we'll start with Article 22, facilitation of formalities. Each contracting state agrees to adopt all practicable measures to facilitate and expedite air, navigation by aircraft between the territories of contracting states. So basically, I'm just dividing it into two. The first part says that, let's say, for example, India would provide all the necessary navigational facilities, let's say ATC, navigational equipment, so that an aircraft coming from another country, let's say US, they can fly over our territory or into our territory with ease, and they do not face any delays. So further, they are saying, and to prevent unnecessary delays to aircraft, cruise, passenger, and cargo, especially in the administration of the laws related to immigration, quarantine, customs, and clearance. So they are also saying that we will, as a contracting state, or for example, India will not be a reason for any delay to any contracting country that is flying into our country, or any contracting country's airline that is flying into our country, because of, let's say, immigrations or our customs policies or quarantine, etc. So basically this Article 22 is just saying that we will provide such a system which will facilitate all the other aircrafts that are coming in from a contracting state, and also we will prevent any delays. So that was Article 22. So let's jump into Article 23. Article 23 is customs and immigration procedures. Each contracting state undertakes, so far as it may be find practical, to establish customs and immigration procedures affecting international air navigation in accordance with the practices which may be established or recommended from time to time pursuant to this convention. So this is an easy one. They are saying that all the customs and immigration procedures, for example, let's say you're traveling from abroad and coming to India, all the customs, you remember standing in a line, maybe filling up a form, and crossing the immigration, you get a stamp on your passport and all those things. So all those procedures has to be common, or at least it should be as per the convention. It should be as per a certain uniformity has to be maintained between the contracting states, so that it is easy for, let's say, another crew or another passenger coming from another country to follow it. So it is uniformity that they're talking about in case of customs and immigration procedures in Article 23. Article 24 talks about customs duty. Aircraft flying to or from or across the territory of a state shall be admitted temporarily free of duty. Fuel, oil, spare parts, regular equipment, and aircraft stores retained on board are also exempt custom duty, inspection fees, or other similar charges. So remember, all the chocolates that you buy at a cheap price, it's because a duty is not levied by the country, let's say you're going to or coming from. Let's say you're coming from another country to India. Remember all the duty free things that you buy. That's what they're talking about. So they're saying that aircraft flying to or from the territory of a state, so in between contracting states, or in fact even to another state or to another country, when you're flying you won't have to pay duty. They're also saying that fuel, oil, spare parts, regular equipment, and aircraft stores, so all the important equipment as well as spares and fuel and all these things will also be not charged duty when it comes to an aircraft which is coming from a contracting state, right? And they are also saying that inspection fees or other charges will also not be levied. right? So they're talking about customs duty and how other contracting states are exempted in Article 24. Article 25 talks about aircraft in distress. Each contracting state undertakes to provide such measures of assistance to aircraft in distress in its territory as it may find practical. So basically, they are saying that if another aircraft comes, let's say, to India and they are in distress or they are in a state of emergency or urgency, India will provide full assistance to them. So that's all that they say in Article 25. Article 26, investigation of accidents. In the event of an accident to an aircraft of a contracting state occurring in the territory of another contracting state and involving death or serious injury or indicating serious technical defect in the aircraft or air navigation facilities, the state in which the accident occurs will institute as loss permit with the procedure which may be recommended by the International Civil Aviation Organization. The state in which the aircraft is registered shall be given the opportunity to appoint observers to be present at the inquiry, and the state holding the inquiry shall communicate the report and findings in the matter to the state. So I'll give you an example. If another aircraft is coming to, let's say, India, and they have gone through an accident, and there is a case in which many people died or a few people died or are injured, what happens is that India will investigate this accident as per the norms of International Civil Aviation Organization or as per the guidelines of International Civil Aviation Organization, and also the country from which the aircraft belongs is going to send observers, or they are going to observe how this investigation is going to take place. And finally, India, this is only an example, right? India, where the accident has taken place, will submit a report to the country to which the aircraft belongs. So I'll put it simply. Let's say an aircraft comes to India and crashes, for example. India will investigate the accident and send a report to the country from which the aircraft belongs in the presence of the observers from that country, right? So that was Article 26. So Article 27, exemption from seizure on patent claims. An aircraft on flight cannot be seized for violation of patent laws of a state. So a patent law can be, let's say, a spare or a part which has the state has the right on its patent, right? So there would be no seizure. For example, an aircraft is flying to the US from another contracting state, but a part of the aircraft has a patent from the US. So if it's flying over or into US will not seize the aircraft because of patent issues. That's what they're saying in Article 27. Article 28 basically talks about air navigational facility and standard systems. Each state should provide airports, navigational facilities, met facilities, radio, charts, maps, etc. to conform to the convention specifications. So they again, if you look, there is something matching to Article 22, but basically they are saying that there should be a standard, there should be a uniformity when it comes to airports. The layouts of the airport should be, I wouldn't say similar, but more or less people should, when someone from a contracting state is coming into our country, for example, the airport layout should be more or less understandable, right? Navigation facilities, now let's say a VOR or an ILS, the procedures should be quite easy to understand and similar between all the contracting states. Met facilities, so if you look at it, METAR and all these Met reports are almost the same between countries. It is easy to read for the crew. So everything should have a certain sense of uniformity, so that let's say another country, US or Canada or any other airlines is flying to India, they should they should find it easy to understand our procedures, and that is why there is Article 28, and that is it for Article 22 to 28. I hope you understood something. If not, feel free to ask questions on Instagram or you can comment below. Happy learning, guys. Cheers.